Who's smarter, you or the judge? Let's find out today. We'll find out by the end of this video. Um, Welcome back to Part of the People. I'm Estela Martinez, and today we're gonna go over some law, and we're gonna decipher some law and see who's smarter. Do you get it? Do you understand it the way I do? Because the judge sure didn't. Now, judges, attorneys, and prosecutors tend to look down at pro se defendants. And for those of you out there that don't understand what pro se means, a pro se defendant is a self-represented litigant. And so if you decide to fight your own court battles, you would be considered a pro se defendant. The courts don't like that. Judges don't want you to proceed without representation. Prosecutors don't want you to proceed without representation. And attorneys definitely don't want you to proceed without representation. Why? Because it's more money in their pocket. But if you want to represent yourself and if you want to fight your own battle, you have the complete right to do so. They cannot stop you legally. They cannot stop you from doing so. But in all these cases, the one thing that I keep hearing over and over and over again is that we don't know what we're doing. Pro se litigants don't know what we're doing in court. We don't know the law the way they do. They went to school for so many years for this. They studied books this thick and learned them in order for them to become attorneys and ultimately some judges. And one thing that I have noticed, and you will hear this a lot from other pro se litigants, they don't know the law as well as they claim they know it, or they purposely misrepresent the law. And that's a big problem because they're forcing attorneys on us because we supposedly don't understand the law, but then they turn around and misrepresent law, or they ignore law. And that's not a good fair way to move forward. In this last hearing that I had in March 7th, I keep on referring to it as an unlawful hearing, and it was 100% unlawful. And I'll give a real quick reason for explanation for it. Judge Valdez was the first judge that I recused in my case. Once I recused him, he had no legal authority to proceed in the case. At least not until his recusal was satisfied. They assigned a new judge to hold a hearing to hear his recusal. That judge didn't hold a hearing and just dismissed the recusal. That's not a proper way to move forward. They need to be able to take into consideration my arguments as to why I'm trying to get him recused. They didn't take that into consideration, and so that's not a valid order. And so I recused that judge, and they assigned a new judge. The new judge did the same thing ultimately, and I recused her. After that third judge was motioned to be recused, she ignored the recusal. She didn't take action after that, which left my case in limbo. There's no judge assigned at that point that can legally hear any of the motions, any of the arguments, anything that's going on in my case. And then Judge Valdez, the first judge, keep that in mind, the first judge to be recused, reinserts himself back into the case and schedules a hearing for March 7th, which is why I say it's an unlawful hearing. He schedules a hearing for March 7th, and he holds the hearing unlawfully. Now, in the hearing, he made a reference to a law. Actually, all three of them, my own court-appointed attorney, the prosecution, and the judge, all made the same reference to the same flawed statute. And we're going to go over it today. The statute is government code, the Texas Government Code 25.00256. It's called the tertiary recusal motion against judge. Now, I'm going to read you the law here real quick. On Section A, it goes over the meaning of tertiary. It says, in this section, tertiary recusal motion means a third or subsequent motion for recusal or disqualification filed in a case against any statutory probate court judge by the same party. The term includes any third or subsequent motion filed in the case by the same party, regardless of whether the motion is filed against a different judge than the judge or judges against whom the previous motions for recusal or disqualification were filed. That's just a kind of an explanation of what this tertiary recusal motion means. Okay, which means that after the third subsequent motion to recuse. In my case, there was a third subsequent motion. I recused Judge Valdez, I recused Judge Banales, and then I recused Judge Longoria. That was the third subsequent motion for recusal. But Section B states, a judge who declines recusal after a tertiary recusal motion is filed shall comply with the applicable rules of procedure for recusal and disqualification, except that the judge shall continue to 1. Preside over the case, 2. Sign orders in the case, and 3. Move the case to final disposition as though a tertiary recusal motion had not been filed. This is my interpretation. Clearly, the judge, prosecutor, and defense attorney had the same flawed, in my opinion, the same flawed interpretation of this law. It states that the tertiary recusal motion would be the third recusal, which we've already established there was. The third one was to recuse Judge Longoria. Section B further states a judge who declines recusal after a tertiary recusal motion. So after the third motion to recuse, the judge who declines the third one, which means that they would have had to assign a fourth judge into my case. And that judge, no matter what his decision was, would be in charge of moving the case forward to preside over the case, assign orders in the case, and move the case to final disposition. In this case, Judge Valdez, the first judge to be recused, and whose recusal was not satisfied 100% yet, decided to reinsert himself into the case. Guys, am I the only one here? Like, do you all understand this? I challenge you all to Google it real quick. It's the Texas Government Code, section 25.00256, tertiary recusal motion against judge. It's not a very long read. It's a couple of paragraphs. Read it and test yourself. How intelligent are you? Are you smarter than this judge? Because I think most of us would be, and that's pretty sad. I think this calls for this judge to be pulled out off of his bench. I mean, to begin with, he stepped out of his legal authority, out of his judicial authority, to hold an unlawful hearing, to move the court against a defendant, and to make these false claims and this misinterpretation of law to justify his unlawful actions. This is not good. Test yourself. In my opinion, I've read over this over and over and over again. I've actually asked a few more knowledgeable people than I am. I've referenced some case law, and I 100% believe and know that he was wrong in his ruling. And so test yourself. You know, they claim that us pro se litigants are not smart enough for this. What are they doing on the bench? What are these attorneys doing with holding their bar cart license? What are these prosecutors doing? Or are they just all against us and we never had a chance? Find out. As always, follow me. If you're a judge, prosecutor, attorney, leave a comment.